Tēnā koutou, tēnā koutou, tēnā koutou katoa. Kia ora everybody, Sheila Murray here, Director of Development and Alumni, and it's my team that is putting on this webinar tonight. This is the second in our series of March with Otago, and the last and final speaker is on this Thursday night. But tonight we're very lucky to have two wonderful presenters who are presenting on a webinar series called Dignity and Mana as Principles in New Zealand Law. And it's my great pleasure to introduce Associate Professor Anna Hai and Mihiata Pirini tonight. Both of them are going to do a lovely presentation. And at the end, we will have the opportunity to ask them some questions. That is via the Q&A function at the bottom of your screen. So please type your question into the Q&A section at the end, and we'll hopefully have the opportunity to ask some questions of the presenters. So just a little intro on both of our great speakers tonight. So Anna is completed her doctorate at the University of Oxford as a Rhodes Scholar and was Distinguished Scholar in Residence and American Council of Learned Societies Postdoctoral Fellow at the Loyola University Chicago School of Law. She is one of New Zealand's foremost experts on evidence law and is a socio-legal scholar who has adopted a law and action approach to three main areas of interest: feminist theory, sexual violence, evidence law, and Chinese law. That'll be interesting, Chinese law. She is co-director of the Otago Centre for Law and Society. In 2022, Anna was awarded the Royal Society Early Career Research Excellence Award for Humanities and the New Zealand Law Society Honourable Rex Mason Writing Award, and the Law and Society Association of Australia and New Zealand Article Award with Mihiata Pirini, called Dignity and Mana in the Third Law of New Zealand. So Anna. And then we also have Mihiata tonight. So Mihata's research interests are in public and administrative law, and specifically in the Treaty of Waitangi's influence on public decision-making and the relationship between tikianga and state law. She also focuses on the emerging field of legal design. Her LLM thesis, which she completed in 2020, examines the accessibility of the Maori land court through a legal design and the kaupapa Maori research and theoretical framework. In 2022, she was awarded the New Zealand Law Society Honourable Rex Mason Writing Award with Anna for this the article, which is Dignity and Mana in the Third Law of New Zealand. From 2011 to 2019, she was in legal research and advice roles in the public sector, first at the Law Commission and then in Crown Law's Treaty of Waitangi team. So we're very lucky to have them both here at Otago, and it's over to them. And just a reminder, Q&A questions down below. Thank you, everybody.
Tēnā koutou katoa. Ko Mihiata Pirini tōku ingoa ko Ngāti Tūwharetoa me whakatoa ngā iwi. He uri no kōtirana me ingarangi hoki. Really pleased to be here tonight to talk to you about the research that Anna and I really enjoyed working together on.
Tēnā koutou katoa, I tipu mai o Australia, kei Ōtepoti tōku kāinga I Naianei. Ko Anna Hai tōku ingoa, tēnā koutou, tēnā koutou, tēnā koutou katoa. Like Mihi, very pleased to be here. We really enjoyed working on this article, so it's lovely to have a chance to talk about it with a wider audience. So we're going to go back and forth between the two of us, and I'll begin by introducing the project as a whole. So our interest in this project really began as an interest in dignity. So dignity is a remarkably prominent concept in international human rights law, and dignity talk is becoming increasingly common in domestic legal orders too. So we wanted to know, what is the role of dignity as a legal value or concept in the New Zealand context? And as this quote from Justice Hammond shows, dignity is a concept that can live and breathe in the real world, including in the law. So in modern Aotearoa New Zealand case law and legislation, we keep seeing dignity popping up, and it's one of those things where the more you're thinking about it, the more you kind of see it. So we were thinking that the prevalence of this dignity talk in our legal texts suggests that even here in Aotearoa, we're increasingly embracing dignity as a framework for making a variety of legal claims. But of course, that raises some questions because human dignity is a famously contested concept. It's open to the critique that it simply means whatever one wants it to mean. So we think it's really important not to just gloss over its meaning and its use in our law, but to really unpack and puzzle over its deployment. So that was the starting point or the hook for this research. Importantly, though, dignity in New Zealand is being used in a context in which two cultural legal traditions are meeting, Māori and Pakeha. And of course, when different legal traditions meet, it's inevitable that associations are drawn between different concepts that have distinct and discrete cultural heritages. So dignity, as it's used in international law, represents certain Western traditions and cultural assumptions. And in New Zealand, we noticed that this Western-derived concept of dignity is frequently being used alongside the purportedly related Māori concept of mana. And there are some examples of that on the previous slide, just at the bottom there. Thanks, Mihi. So mana is a really rich and complex and distinct concept, and it's one that doesn't correspond neatly to dignity. So we were also really curious in this project to think about the character and appropriateness in New Zealand law between mana and dignity.
All right, so I want to talk now about our research questions and our method. So we basically had two main research questions for this project. And the first one was the one that Anna has already touched on. How is the idea or value of dignity expressed in New Zealand law? So as Anna noted, dignity in New Zealand law and in law generally is a contested concept. So how is it expressed in New Zealand law? And to answer that research question, we took an empirical approach. We looked at legal databases, describing, covering both law from the courts, so case law, and law from Parliament, so legislation. And we looked across those two sources to build up a picture of the way that legislators and judges are using the term and the concept dignity in law. So legislation was actually quite a straightforward task because the word dignity appeared in about 30 acts of Parliament. So we had a kind of confined data set that we were able to collect the data and research and analyze it. Case law from the courts was a bit trickier because when we searched for the word dignity in cases and cognate terms like dignified, we had about 4,000 results back. So we had to narrow our scope for case law. And we did that by really focusing on those cases where dignity wasn't just mentioned by the judge in passing, but it was explored in a bit more depth and actually kind of activated as a concept in the case. So using that approach of looking at our databases, we built up a picture of the use of dignity in New Zealand law. And I'll come back to our research findings shortly on that. But before I do, I want to look at our second research question for this project, which was also one mentioned by Anna in the beginning of this presentation. How are dignity and mana being associated within New Zealand law? So we are aware, Anna talked about examples of where they're being drawn into some kind of relationship. But, you know, what is the nature of that relationship? Are judges and legislators treating dignity and mana as these interchangeable concepts that just mean the same thing? Or do they recognize that there's some kind of distinction between them? And if they do, what is the nature of that distinction? Is there some kind of overlap, as this kind of Venn diagram might suggest? And if so, what sits in the middle of that Venn diagram? So this was our second key research question. Now, in order to answer that question of how dignity and mana are being associated in New Zealand law, we had a prior kind of research question that we needed to think about, which is, what is mana in the context of tikanga? And it was important to us that we were looking at mana in its tikanga concept, since mana is a concept that comes from tikanga Māori. It's not a concept that originates within legislation made by Parliament or cases made by the courts. So we wanted to situate it in its tikanga concept. How did we gain an appreciation of mana in that context? And researching tikanga for legal scholars anyway, it is quite tricky, because some would argue that the most appropriate research methodology when considering tikanga is to go and see it in practice, because tikanga finds expression in the way that it's applied case by case, and it might differ in the way that it's applied between different Māori groups, different hapu and iwi, for example. Now, we didn't have the time or the scope within our research to do that kind of field work, so we decided that we would research mana by looking at those sources, written sources by really authoritative Māori scholars who we knew had experience with the way that tikanga is applied in real life. So, and for those who, I've been using the word mana as if we kind of understand what it means, but if you look up a dictionary definition of that word, you'll find that English terms to use to describe it are things like authority, reputation, status, or influence. So, you know, there's the dictionary definition, but we wanted to go a bit deeper, so we relied on those written sources from those authoritative tikanga scholars. People like Pirini Mead, who wrote this book, which was published in 2016, Tikanga Māori, Living by Māori Values, and it's considered a highly authoritative text when it comes to understanding tikanga Māori. So we relied on those written sources to build up this appreciation of mana within the context of tikanga. And again, I will discuss our findings on those research questions shortly, but first I'm going to go back to Anna to talk about dignity as a legal concept more generally.
Thanks, Mihi. So I'm just going to spend a bit of time now introducing the concept of dignity as a legal principle, both in terms of how it's used in international law, but also in terms of in the New Zealand context. So I noted at the outset that dignity is a really remarkably prominent concept in law, and that's really a shift that has occurred in the latter half of the 20th century, so post-World War II, and in part as a response and rebuttal to World War II, I guess. So dignity has been invoked in key social and political movements of the 20th century, including movements against Nazi ideology in Europe, against systemic racism in America, and also against global poverty. So it's also, in addition to emerging in the international law context, it's also been incorporated into the constitutional texts of numerous states as a foundational and purportedly non-violable, inviolable principle, including in Germany, Israel, and South Africa. Also really interesting is that even in jurisdictions that don't have any express constitutional reference to dignity, and most obviously here I'm thinking of the US, you're increasingly in the latter half of the 20th century seeing courts using dignity to do some real heavy lifting in terms of using it as a meaningful concept that has substantive outcomes, and particularly it's used as a framework for evaluating the constitutionality of law. So, and I'm sure you can all think of some examples of this. So, for example, key cases from the US Supreme Court on abortion, where dignity has been used to explain the importance of the right to choose as an aspect of autonomy, but also dignity is appearing on the other side of the debate with arguments about the dignity of life being put forward in terms of restricting access to abortion. Likewise, in legal arguments about same-sex marriage, we see dignity again being used on both sides of the debate. It's used to support equality arguments, but also conversely to suggest that the dignity of society or the dignity of marriage might be implicated by change. So what those examples illustrate very neatly, I think, is that dignity is a really contested concept. It also has really strong normative pulling power because, of course, who doesn't believe in dignity? So it's a great way to add some moral authority or weight to a particular legal argument, and you frequently see it being used in that way. But of course, it's also open to the criticism that it simply means whatever you want it to mean, and it's actually quite an empty concept. So it's been described for that reason as the shibboleth of perplexed and empty-headed moralists. So there's this real concern with dignity. Does it just mean whatever you want it to mean? And that might well be a valid critique. And as we noted, that was one reason why we wanted to look closely at how it's used in New Zealand. So from all of this, we can see, as I said, the normative status of dignity is really settled and strong. Everyone subscribes to the idea of dignity, but its semantic status is far from settled. So what do we actually mean by dignity as it's used in Western law and philosophy? So in modern Western legal tradition, dignity is commonly used to make two claims. The first is an ontological claim that all people, by virtue of being human, have an inherent worth or value. And then secondly, there's a relational claim that by virtue of that inherent value, we should be treated in a certain way with a certain amount of respect. So there seems to be that core idea, which there's consensus and agreement on. But beyond that, there are multiple conceptions of dignity that are possible. And we see that in the examples I just gave, where it's used on both sides of the debate. So for example, we might say that the assumption of inherent worth derives from a theological premise, such as we are all made in God's image, or it might derive from a secular premise, such as we have dignity because of our unique capacity for rationality and our unique capacity for autonomy. And indeed, in law, dignity is really closely associated in the Western legal tradition, I should say. It's closely associated with that value of autonomy, and it's also really closely associated with the value of equality. So there's competing conceptions, and those are just a few examples of that. And those competing conceptions and contests about what dignity means can lead to really interesting outcomes. And again, those often involve dignity being used to make competing and opposing arguments. So to just give one more example of that, there's an infamous French case involving a man of short stature by the name of Wackenheim. And he rented himself out to be tossed around at parties for sport as entertainment. And this resulted in what's known as the dwarf tossing case, where a local ban on dwarf tossing was put in place, and Mr. Wackenheim appealed that ban. And he appealed it on the grounds that it was a violation of his dignity, that as a dignity-bearing person, he argued he had the right to autonomy, and that meant he had the right to do what he would with his body. But on the other hand, and the court actually did uphold the ban on dwarf tossing, you also see the idea of the collective dignity of mankind being brought into the debate. So the idea that this is offending the dignity of humankind when we allow this to happen. And that argument actually won out over Mr. Wackenheim's claim about his autonomy. So all that to say, looking at how dignity is deployed in a particular context, and ours is the first study to do that in New Zealand, it raises a bunch of really interesting questions. Is dignity meaningful? Should it do this sort of heavy lifting in law? Is it ahistorical and transnational, or is it culturally situated? Really importantly, is it just meaningless lip service? Is it a smokescreen that judges can use to hide their outcome-based reasoning? Or is it a useful touchstone principle that helps us to balance competing interests and rights claims? And one of the key, and that's a really big body of scholarship that addresses those bigger questions. And one of the key voices in that broader body of literature, Professor McCrudden, has argued that those existing debates, those larger meta-narratives, I guess, of dignity in law would be enhanced by more contextual country-specific studies of the discourse of dignity in a particular historical, social, cultural, legal, political context. So that's really what we set out to do, to try to bring New Zealand into that comparative literature. So having introduced you to a bit of the literature on dignity in law, I'm now going to pass over to Mihi, who's going to talk about what our findings were in terms of how dignity is being used in New Zealand.
So what we found broadly, this is our high level finding when it came to the way that dignity is expressed in New Zealand law, is that conceptions of dignity in New Zealand law are heavily associated with protection of individual autonomy, the protection of human rights. So this is a conception that Anna talked about just now. So the individual has a particular status inherent to them, and that status needs to be recognised and upheld and protected against incursions from more powerful entities like the state. So that's the conception of dignity that we see most often in New Zealand law. So we found that the dignity concept appears in case law from 1967. So there was a Court of Appeal case called R. Mackay, where the defendant was put under the influence of a truth serum. And the court asked, was this act of delving into their unconscious mind in conflict with their dignity? So that was really the way that dignity played out in that case. It was about, what individual rights attached to this person and how do we protect them against incursions from the powerful prosecutorial authority of the state. And so that was in 1967, and then subsequent to that, future references to case law also drew on this conception of dignity as being something, a lens that can be put on an issue in order to protect an individual's rights. And that correlates, I think, with that post-World War II context where we are responding to the horrors of Nazi Germany. We're seeing the growth of the civil rights movement, the flourishing of human rights generally. So our law and dignity in our law really correlates with those international movements. In terms of legislation, we saw references to dignity from the 1990s, so a little bit later in time. And in fact, the first reference was in the New Zealand Bill of Rights Act, which protects the rights of people who are arrested or detained. And it says that they must be treated with respect for the inherent dignity of the person. So again, in that context of a powerful state trying to encroach on an individual's rights, that's the conception of dignity that comes through in the legislation. So that framing of dignity with individual rights is really kind of closely knitted together in our law, we found. An interesting exception that we found to this overall finding is one that Anna's already had on an earlier slide. It's the description in the Oranga Tamariki Act of mana tamaiti and the use of the term dignity to define that concept. So the Oranga Tamariki Act regulates and deals with the protection of young people and children who are seriously at risk. And the Act contains this concept of mana tamaiti, which means, so mana, which is the concept we're concerned with, tamaiti meaning child, and tamariki, children. So the Act defines this concept to mean the intrinsic value and inherent dignity derived from a child's or young person's whakapapa, their genealogy, and their belonging to a group, to a family group, whether a whānau or hapu or iwi or cultural equivalent. So this idea here, which draws on the concept of dignity, it treats dignity as being concerned with someone's belonging to a group. So it is concerned with the individual, but it also places them in the context of the group, the family group. And so it comes into quite a sharp contrast with other references to dignity in our law, which are really solely focused on the rights of the individual. So we see mana tamaiti kind of shifting away from that, towards a conception that embraces a person's place in their community. And it happens that it builds that definition around the concept of mana tamaiti, so a concept which also refers to mana. So not only is this example interesting for how it conceives of dignity, it's also an association example of mana and dignity being put together. But the main point here is that it moves away from the dominant conception of dignity as attaching to the individual. And then in terms of mana, as we found that concept in the context of tikanga, so what is it? Some key findings in terms of its contrast with dignity. So generally we found that mana is, you might describe it as more fluid than dignity. It has more fluidity to it. So for example, we read that mana can ebb and flow according to tikanga authors. So particularly when we think about mana tangata, which is a form of mana that attaches to people, tangata, this can increase and it can recede. So for example, writers spoke about mana being able to be acquired by a leader who wisely administers their tribe at home and conducts successful military campaigns abroad. So mana can ebb and flow. And this departs from the conception of dignity being something that we are all born with and that's inherent to us and that we can't get rid of, and that can be used to kind of shield us against more powerful, the more powerful state. And another example of the way in which mana is more fluid than dignity is in the way that recognition of mana, a person's mana, depends on their community. So we read authors who had noted that really a leader's mana depends on how their family group, their whānau group or their hapu perceives them. So if they have taken steps to enhance their mana and increase it, then that will be recognised by their community. But by the same token, the community may decide that that person has done acts that are not mana enhancing. And so that recognition of their mana will decrease. And that again departs from the idea of dignity being an inherent value that we all hold in us as humans. And so mana really has this connection to community. A person's mana depends on their community in a way that dignity, or at least the kind of individual human rights conception of dignity, doesn't, which was an interesting distinction. And it's probably unsurprising that mana departs from dignity in this way, because mana emerges from a system that is inherently relational. So tikanga Māori is constructed around the idea of whanaungatanga. It's been described by a prominent Supreme Court judge in New Zealand as the glue that holds the system together, whanaungatanga, which is connectedness, relationships. So tikanga Māori depends on relationships, and that flows through into the idea of mana being determined in part by what your community is willing to recognise of you. So in sum, mana and dignity are not the same, and they don't map neatly onto each other. And, you know, we have this kind of diagram, which I've introduced earlier. I think our research acknowledges the possibility that there's some overlaps between mana and dignity, and remains alive to that as a possibility. And we might come to explore that or discuss that more later, but they're not the same, and they shouldn't be treated the same in law. So having come to those conclusions, we can now talk about what we found in terms of the way that the two concepts are being associated in law, and are they being treated as equivalents, or are judges and legislators recognising these differences?
Yeah, so I'll take that point up with this next slide, because as Mihiata said, we found this really interesting, this idea of the associations being drawn in our legal system between dignity and mana. So, you know, our research and review of tikanga experts and of Western international human rights principles clearly shows that these are really distinct concepts, and one is very much associated with autonomy, and the another is premised on a system that assumes whanaungatanga. And so that raises some questions about why we're seeing these associations being drawn in law. And it also raises some really interesting questions about the potential for a very New Zealand specific conception of dignity to emerge. But that's something that I'll save for Mihi to talk to at the end. So without wanting to preempt that, I want to talk a little bit now about what we did find in the data in terms of how are these concepts being associated in our legal system. And we did find that there was an assumed linkage between dignity and certain tikanga concepts evident in a number of legal contexts. So for example, with case law, looking for cases that discuss both dignity and mana, we found 40 cases of interest, and these spanned various contexts. So just to give you a bit of a taster, I guess, of some of these cases, there were quite a few employment law cases, with several cases referring to the need to deal with disciplinary matters in a way that respects mana and dignity. And that's drawn from the wording that's used in a particular collective employment agreement that actually uses the phrase mana and dignity. So that's the employment context. In the criminal context, particularly in the criminal sentencing context, you see courts saying that poverty resulting from loss of land, language, culture, rangatiratanga, mana and dignity can be taken into account in sentencing. Which again, I think is an example of dignity being used to sort of try and explain a certain loss that is occurring, and that is taken into account in sentencing. And then also in employment disputes context, we found plaintiffs making mana-based arguments to support their claims under the Employment Relations Act. So the Employment Relations Act allows for compensation for loss of dignity, and we saw mana being used, the language of mana and the concept of mana being used to ground the arguments pertaining to the loss of dignity under that act. What was interesting and probably not too surprising was that in none of those cases were the courts actually interrogating, exploring or defining those concepts, simply sort of using them as sort of, you know, presumably, you know, not in need of explanation or or defining. And they certainly weren't considering explicitly the associations between mana and dignity. So there's room for more jurisprudence to emerge in this space. We also found the mana and dignity association being drawn in 2 items of legislation, as indicated on the slide. So we have the Substance Addiction Act of 2017, which refers to the need to protect and enhance mana and dignity, where people are being compulsorily assessed and treated in relation to substance abuse. It's not clear that mana and dignity are being treated as equivalents. We're not assuming, and indeed the fact they use both terms would sort of suggest they're not treating them as equivalents, because if they were equivalent, you would just use one or the other. So that might suggest a different concept, that the conceptual distinctions between the two are being recognised, but they're not being puzzled over, they're not being explained, and that's part of what we were wanting to do in our article. The Oranga Tamariki Act, and I will say, by the way, the mana tamaiti, the reference to mana and dignity was added after 1989. I can't remember the exact year of the amendment. So NZ Bora was the first piece of legislation we found using dignity. So don't let the year of the act fool you. Oranga Tamariki does use this idea of mana tamaiti, but it came in a bit later, post NZ Bora. So Mihi's talked a little bit about this one already, and we found this particularly interesting because, as Mihi referred to, it seems to use the idea of dignity to help explain mana tamaiti rather than vice versa, and it seems to be using quite a different understanding of dignity here. It seems to be understanding dignity as something that is inherently relational, something that, rather than deriving from our autonomy or requiring that our autonomy is recognised, here it looks like dignity is seen as something that derives from our interconnectedness, particularly from the child's belonging. It's because of their belonging and their interconnectedness and their whakapapa that they derive their dignity and inherent value. And we found that really, really interesting because, as will be clear, I think by now, in Western philosophy and law, dignity is really strongly associated with autonomy, with the individual prior to society. And indeed, elsewhere in the Oranga Tamariki Act, there's this express tying of mana tamaiti to the foundational tikanga value of whanaungatanga in terms of the kinship which grounds certain responsibilities based on obligations to whakapapa. So we thought this was a really interesting use of dignity and mana in association with one another, and one that sort of pointed to some potential future directions for dignity as a distinctly Aotearoan concept. And with that, I'll pass over to Mihi to talk about this kind of final piece of the puzzle.
So we thought about, how do we understand these associations? What implications can we draw from this? What thinking does this really lead to? And where should we go from here? So I've just put a couple of talking points on the slide to reflect on, but I'm hoping that Anna will jump in when she wishes to. And thank you, Anna, for making that clear about the 1989 Oranga Tamariki Act. I had meant to note that was a legislative amendment that happened after 1989. So I guess the first question you can ask is, are these associations a good thing? And I've put there on the slide, are they indicative of a genuine bijural shift? So one of the big conversations that is occupying us in the legal field at the moment, particularly in universities and amongst legal academics, is are we moving towards a legal system which recognises 2 strands of law? So Western law derived from courts and the legislation, and tikanga Māori as a freestanding legal system of its own. And we are seeing examples beyond mana and dignity where these 2 forms of law are mixing and courts are drawing on concepts from tikanga Māori and applying them in their own particular form of law produced by the court. So there's mixing between these 2 systems. So we talk about a bijural shift, a shift towards a legal system with 2 strands of law. And some will argue that this is a good thing. Some will argue that this is a thing we need to be cautious and careful about, because it can be very tricky for the dominant Western legal system when it's picking concepts from tikanga Māori and drawing them into its own law. And we need to be careful and thoughtful about how that happens. So there's a lot of arguments kind of swirling around this bijural shift. But we were interested, Anna and I, to think about whether mana and dignity associations can be seen as indicative of a genuine bi-jural shift, so a genuine effort on the part of the courts and the legislature to take account of tikanga Māori as a system of law and to draw some of tikanga Māori's concepts into itself and to kind of activate them as a form of law. And one of the things we thought about there is this risk that perhaps this drawing on of Māori concepts and words is really surface level, and it's just happening at the level of, well, we kind of broadly understand what the word mana is. It's probably one of the more commonly used terms or concepts from tikanga across a range of social contexts. So perhaps we're finding judges and legislators thinking, let's take mana and let's kind of use that to enrich our own legal system without necessarily understanding the nuances of the differences. So there will be some argument that this association is happening at the level of words only, and it's not really productive or thoughtful or genuine in any broader way. And I think that Anna and I kind of landed on the need to be very aware of that risk. And I think that we would both agree that there are some examples in law where, because the judge or the legislator really hasn't taken the next step of thinking about how mana and dignity differ, we can't be sure that that thinking is actually going on. And until there is evidence of that, then we might actually believe that we are just at the level of words and that there's no deeper thinking, kind of no deeper meaningful engagement with these concepts and the differences between them that's going on. So that's kind of speaking to that first point there. And similarly, the second point, I think, we didn't see, as Anna said, a lot of evidence of judges and legislators taking care to identify and engage with the differences between these concepts. And then we also thought about, well, what is the future for dignity as a concept in our legal system? Is there potential, putting to one side the differences between dignity as a concept and mana as a concept, and focusing back on dignity and what it means and how it's expressed in our law? We thought about the future of that concept. And I don't know if Anna would like to jump in at any stage to kind of speak to that point in particular.
Yeah, I'm happy to. Yeah, I think we think, in addition to this kind of concern that mana might sort of be subverted by just being kind of simplistically associated with dignity, keeping that concern in mind, we still think quite optimistically that there is potential for a really bicultural and uniquely New Zealand, I guess, conception of dignity to emerge. Because as I said earlier, different conceptions of dignity are emerging in different contexts. That's one of the critiques of dignity. But I think, I mean, I can't speak for Mihi, but I'm a bit of a realist. I think dignity is going to continue to be used in law. It's going to continue to play this key role. It is foundational in so many constitutional and international texts. So that's kind of, you know, the horse is bolted, I guess. So the question is, well, what are we going to do with that concept? It is in our legislation, it is in our case law, and it does have this really strong moral authority. So I think there's a really compelling argument to be made, which we tried to do in our paper, that if dignity is going to continue to feature as a legal value in Aotearoa today, as this bijural shift is happening, we need to think about how we can have a more Indigenous concept of dignity emerging in New Zealand, and one that does not supersede that separate concept of mana, but can we think about dignity as a mana-informed concept in the New Zealand context, one that's grounded and particularly relevant to our social and political and cultural concept. And that's going to involve not just drawing on mana, but actually acknowledging that in tikanga, the sacredness of the person is due to a whole bundle of attributes. This is the phrase that Moko Mead uses. It's not just about mana, but also more generally, there are other concepts such as Māori that inform the inherent value of people in the tikanga worldview. And is that something that can be brought in to enrich our concept of dignity? So maybe, for example, in the future in New Zealand, dignity won't just be about autonomy. Maybe it will still be about autonomy and equality, but also about our interconnectedness, our whanaungatanga, rather than simply going with this very monocultural idea of dignity that has emerged in international law. Yeah. So I think unless you wanted to jump back in, Mihi, I think that's probably enough from us, and we'd love to hear some of your questions. I did just note in the chat that somebody, thank you, Kathy, has pointed out that the Oranga Tamariki change happened in 2017, so a pretty recent change. And we did also, I'm not sure if I'm supposed to be reading these questions or we did also have
you go, Anna. Yeah, you go.
Okay, we had someone also make the point about mana in the non-human world, and this is actually a really important point. I'll pass back to Mihi in a moment, but this was something that also came up in our review of. So this article is focused on dignity. We weren't trying to do a complete, survey of mana as it's used in law. But if you were to do that project, which I think would be really interesting, you would see, as Daniel has pointed out, that there is reference to the mana of, for example, Te Urewera as a place of spiritual value with its own mana and modi. The idea that places, trees, animals have mana is a really interesting one, which I know not very much about, but it does bring to mind a similar debate, I guess, or discourse and discussion in terms of dignity, and whether there's something different about human dignity, or whether that is a concept that could be extended to non-humans as a way for grounding certain legal claims. So I think that's a really interesting point. Did you want to add anything about that, Mihi?
Yeah, thanks, Anna. A really interesting question. And yeah, we did actually talk at the beginning of our project about surveying the use of mana in the law, in the legal system, as opposed to just really kind of trying to hone in and focus on its use in a tikanga context. And then we decided we didn't have the scope to do that project, but I agree it would be extremely interesting. And I think that it would have to cover the use of the term mana in those contexts where it's being used to describe non-human entities. And it might also need to cover off, well, it would cover off usages of mana that we've seen more recently by the courts in cases like Alice and R, where the courts were looking at whether mana can survive someone's death, whether our legal system should recognise that, and therefore what that should mean for the law on whether an appeal can continue after the appellant has died. So we are seeing, in these examples from the statutes that have been put in the chat, are places where the state legal system is taking the concept of mana and using it to express an important idea. And that feeds into that whole conversation about how the state legal system is doing that and who holds control over how that's done. So yeah, there are some big questions there.
We've got a couple of other questions, and I know that only us can see them, so I'll read one of the questions out. Having explored the relationship between dignity and mana in some detail, do you consider that looking for connections or synergies between other first and second law principles beyond dignity and mana might be a productive way to go about identifying and reaching consensus on the as yet unsettled constitutional fundamentals of the third law? Or is that too much of a compromise of the distinct ideological and jurisprudential basis of each legal tradition?
Good question.
Big question.
So I guess my first instinctive response would be, in thinking about our research and our experience of looking for synergies or connections between mana and dignity, is that I think synergies are useful, but perhaps we run the risk of, again, I just think there's a big risk of misinterpretation and misunderstanding here when we're comparing two legal systems. And so where Anna and I settled was, we are concerned fundamentally with the concept of dignity within the Western legal system, and how that can be informed and enriched by ideas from what we call first law, or tikanga Māori, the first law of this land. So I hesitate to suggest that looking for synergies across other concepts would be the way to go to do that project. But it's probably just going to happen that way anyway, because we know that the courts are really interested in this and they're already doing it.
So do you think the mixing of the Western legal systems and the Te Ana Māori is moving in the right direction? Do you think that's the direction we'll be going in?
I think there's the right direction. I think we have to, I think we have to acknowledge that the state legal system is wanting to, or there's a kind of a real concern, particularly I'm thinking about the courts and the judges. They're very interested, or I've seen evidence that a number of judges are really interested in these issues and in tikanga Māori, and in, you know, we've seen it through this presentation, the concept of mana. How do we make sense of that in a Western context? So there's an interest there, there's an enthusiasm. I think that I've seen evidence of a real commitment to doing that appropriately, doing it carefully and doing it well. So those are all positive signs.
Yeah, good.
Yeah.
All right, I've got another question here. Great presentation, thank you. If mana is relational and is used in the legal system, is it the individual on trial or their whānau iwi community?
Should I just jump in? We didn't really see, I wouldn't say there's been examples of mana being on trial. We saw mana in the criminal context. The place we saw mana come up was in relation to sentencing, and this recognition about a collective group loss that can have an individual impact, which might be relevant to sentencing. So I think what we saw going on in the criminal context was an acknowledgement that people are not just individuals, that they come situated in a broader context, whether they're Māori or Pakeha. That's always true. And again, I think it speaks to the idea that as we start to think about the value of the person, there's a great deal of value in not having a blinkered focus on autonomy, but actually thinking about belonging and whanaungatanga as informing and something from which our dignity derives.
Yeah, absolutely. Great. Okay, well, we're coming to the end of our time. I think it's only got a couple more minutes to go. So there's a question here. Would the Western concept of reputation, in inverted commas, as used, for example, in the law of defamation, be closer to the concept of mana?
I think I don't think it would necessarily be closer. I think there would probably be an overlap. And reputation was probably the closest concept in the Alice context between, so mana was used in that sense of reputation. So there's definitely an overlap there. But it probably, in terms of a Venn diagram, it's not going to fit neatly either. There's going to be some kind of differences and some kind of overlaps. But I think that is certainly one way that we see the term mana used in kind of everyday language, and also in the courts and in the law is kind of treating mana as reputation. So there could be some fruitful avenues to explore there and possibly think about the same kind of research project. I guess the thing that was interesting for us with dignity is that dignity has this, extremely important constitutional and rights-based status in the law, as Anna talked about. So that's why we focused our attentions on that particular relationship.
Great. Okay, that seems to be the end of the questions. So I'll just like to take the opportunity to thank you, Mihi and Anna. It was a fantastic presentation, a lot to think about, and I know food for thought for me. Oh, something might have just quickly popped up in here. It's people just saying they're very appreciative of your mahi and time. So thank you so much. As we said at the beginning, this has been recorded, so we will be sending this out to alumni. So just like to once again thank you very much for your time, Mihi and Anna, and thank you for all of your hard work and mahi. Thank you.
Kia ora, thank you.
Kia ora, thank you.
Kia ora.